Good morning, everyone, and welcome. Our first case for argument this morning is United States versus Alfredo Viveros Chavez. Dean Chemerinsky, welcome.
Good morning. May it please the court. My name is Erwin Chemerinsky, and I represent the appellant Alfredo Viveros Chavez. The issue before this court is whether equal protection is violated by a federal statute that used 99% of the time against those of one race, was adopted with an express racist history. There are two specific questions. First, whether the Arlington Heights framework applies to a criminal statute in the immigration context. And second, if so, is there sufficient proof of discriminatory intent? I want to focus on the second question, though I'm glad to discuss the first, because it was the basis for the district court decision and the basis that other courts of appeals have used for their ruling. There's no dispute that the 1929 statute was adopted with an express racist history. The district court concluded that here. Therefore, the issue is, was the 1952 statute a reenactment or a new law? Did it, in the words of the Supreme Court, purge the racist history of the 1929 statute? And was there discriminatory intent behind the 1952 statute?
Actually, if I could interrupt on that very point, the Supreme Court has never adopted that as a legal standard. There is no requirement to purge, or that the legislature purge in a deliberative way a racist taint from a prior enactment.
I think it is implicit in the Supreme Court's decision in Hunter versus Underwood, and it's made more explicit in Justice Alito's concurring opinion in Espinoza versus Montana Department of Revenue, and also in the opinions in Ramos versus Louisiana. And that would be the basis for saying that there has to be something that indicates that there was a change.
The problem is that Abbott versus Perez explicitly rejects this argument.
But, Your Honor, in Abbott versus Perez, the United States Supreme Court was explicit that it was not a reenactment of the statute, but a new statute. Here I would direct you to the language of Abbott versus Perez, specifically at 138 Supreme Court 2325. Quote, "Nor is this a case in which a law originally enacted with a discriminatory intent is later reenacted by a different legislature." What makes that different here, Your Honor, is this was a reenactment.
Well, that was a descriptive statement. It wasn't a suggestion that a different rule would apply.
But that does pose for you the crucial question. Is this a reenactment, which Abbott in the language I just said it wasn't, or is this a new statute as the district court held?
My point is that distinction between a reenactment and a new piece of legislation isn't a trigger for a different standard of review, for a different rule. The Abbott decision explicitly ruled out any obligation to purge the taint, and any flipping of the burden and placing on the government the obligation to establish that the statute that's under review in a specific case purge the taint of a prior discriminatory statute.
I would disagree, Your Honor. We don't have any dispute that the 1929 statute was adopted for a discriminatory reason.
Understood.
We also have in the history, the Senate report, the congressional record, that they said that the 1952 statute was, and I'm going to use the words of the Senate report, a reenactment. And we have in Hunter versus Underwood, the Supreme Court saying the fact that there's minor changes in a statute doesn't eliminate the prior discriminatory intent. And this statute was minor changes.
Hunter, though, didn't involve a reenactment of a previous statutory scheme. It was a constitutional provision, a state constitutional provision that had been under review and had, in some respects, been pared away or narrowed by judicial decisions. And that was the reason for the descriptive language in Abbott about the status of the law that was under review in Abbott. And the court made clear that the court's obligation, or the party's obligation and the court's obligation, is to examine the intent of the legislature that it adopted the statute that is presently under review before the court?
I think this parallel to Hunter v. Underwood is strong here. The law was initially adopted in Hunter v. Underwood for racist reasons. There were minor changes over time, but the court still found that the initial racist motive proved discriminatory intent. Here, if you look at what happened in the 1952 statute, and this is where we disagree with the district court, there were minor changes only to strengthen the statute. Under the 1929 law, it had to be proved where somebody illegally crossed the border. The 1952 statute is enough that somebody is found in the country. Under the 1952 statute, it is the same provisions as the 1929, other than making it stronger.
Why does it matter that a change is minor versus major if what the legislature in 1952 is doing is looking at the words of the statute and then trying to decide whether the text of the statute, in other words, if someone were to submit the text as is, whether that made sense in the context of what they were considering in 1952?
It's crucial, Your Honor, to ask the question, does the 1952 statute change anything with regard to the racist intent of the 1929 statute?
But I guess my question is, why, if I'm a congressperson, and if I'm looking at whether or not I need to change the provisions of a particular law, I don't think I'm necessarily concerned about what motivated the original language in the first place. What I'm concerned about is when this law is published to the public and people look at the language of the statute, whether it effectuates the policy goals of the current time that I'm concerned with.
But, Your Honor, we're dealing with one statute, Section 1362. We know it was adopted in 1929 with racist motives. The question is, does the 1952 reenactment change anything with regard to it? And what I'm suggesting to you is that Congress just said, we want to reenact it. Let me quote you the words from the Senate report. This is Senate Report 81-1515. It's page 6.
Well, I guess why I'm pushing back at, one of the amicus briefs talks about silent, benign, and I forget what the third one is, reenactments. And I guess, I understand kind of the difference between, the silent one is where they don't even think about it and they just reenact it, just pro forma. The silent one, though, the legislature is actually taking a look at the words of the statute and deciding, okay, well, does it make sense? And so I'm wondering why that doesn't kind of undercut the weight of whatever the original intent may have been.
But here, Your Honor, as I said to Chief Judge Sykes, I think it's important to look at Hunter v. Underwood. Also, Justice Alito's opinion in Espinoza v. Montana Department of Revenue, and the opinions in Ramos v. Louisiana, Justice Sotomayor, and also Justice Kavanaugh, that say when you have a statute with a racist history, there is an obligation to purge the intent. But, Your Honor, and I would respond also in this way to Chief Judge Sykes' questions, if you look at the 1952 legislative history, there's also a great deal of racist motivation expressed for it. What the district court judge said here is, well, there are only 4 quotes that are racist. Of course, as we say in our reply brief, there's a lot more than just those 4 statements. If you look at the Senate report, for example, from 1950, in many different places they express a racist motivation. All Arlington Heights requires is that race be a motivating factor. You don't need to show a majority of the legislators expressed racism, because that's a standard that would never be met. So even if we focus on the 1952 statute, which has to be in the context of the 1929 law, the district court errs in not finding a sufficient racist motivation. It also has to be remembered that this is a law that is used 99% of the time against those of one race. The district court said there was no comparator. But as we point out in the reply brief, there are comparators. You could look at the number of undocumented individuals. Only 80% of them are Latinx, compared to 99% of being used this time against Latinx individuals. You can look at how those from Canada are treated. You can look at those who overstay visas and how they're treated. And Arlington Heights says explicitly, When there is a pattern so stark as to leave no other explanation, that's a basis for discriminatory intent. So when you put all of this together, that's why the district court erred in not finding sufficient discriminatory intent to meet the Arlington Heights standard.
Is there any, is there any data in the record with regard to those comparator classes? In other words, that are more specific or more particularly similar to the situation here? So is there data regarding people that have illegally re-entered and whether or not those people are prosecuted?
Not at that level. I mean, the three things that I would point to are the ones that I said. The percentage of undocumented individuals who are Latinx compared to the percentage that are prosecuted under the statutes, 80% versus 99%. That's in the amicus brief. And then there's the statistics about those from Canada and those who overstay visas who are overwhelmingly white and how they're treated differently. With your permission, I'll save my remaining time for rebuttal.
That's fine, thank you. Mr. Peabody.
Good morning, Your Honor, and may it please the Court, Tom Peabody for the United States. Like Mr. Chemerinsky, I'd like to start with Arlington Heights, but I'm happy to answer any questions regarding the rational basis review that we put forth in our brief.
I guess with regard to the rational basis review argument, the government characterizes this as an immigration statute, but isn't it really a criminal statute? In other words, the statute doesn't dictate who is admitted into the country, doesn't dictate who is deported. It regulates the activity of persons who are already in the United States, and it sets forth criminal penalties for particular actions. Isn't that just a run-of-the-mill criminal statute? How is it an immigration statute?
I think it's both, Your Honor. It's obviously
Well, I guess my question is, how is it an immigration statute? Because there's no immigration ramifications. It's just more kind of various criteria that need to be met before the criminal sanctions would apply.
I think it is a deterrent to aid the other the other immigration provisions that appear elsewhere in Title VIII. I sort of think the Ninth Circuit's description of it is apt. It is that Section 1326 exists to give teeth to immigration laws and more specifically to immigration or deportation orders. I appreciate that distinction and that maybe unlike some of the cases that the Supreme Court has reviewed that maybe more purely could be described as an immigration regulation, this one does have criminal implications. I still think on balance, and I appreciate that the rational basis question is a bit of a thornier one than the Arlington Heights one in our view. I still think on balance, rational basis should apply. This court has applied the Mandel and Matthews lines of decisions in criminal cases before. We cite one of them, that's Montenegro in our brief. And I do not read the Supreme Court's precedents to suggest that the due process concerns that come with a criminal proceeding trump somehow the plenary power of Congress and the executive to make and enforce their immigration regulations, which is the upshot of every single one of those decisions.
Is there a constitutional basis for your argument that deferential review rather than heightened scrutiny applies?
I think
is it basically a separation of powers?
That's exactly right, Judge. That is from where Matthews and Mandel and the like derive. Before leaving this issue, although happy to take more questions on it, I think the rub here is that the challenge is that this is not just a classification on the basis of citizenship or alienage. That clearly always gets rational basis review. The challenge is that it's also one based on race, and so it should get heightened scrutiny, in this case under Arlington Heights. Here's why I think that's wrong. If you take a look at Fialo, it addresses claims like this, which the Supreme Court there described as a double-barrel type of challenge.
But Fialo dealt with who gets let in, right? It dealt with who is admissible to the country. And again, looking at this statute, while the statute may have various kind of deterrent consequences, it says nothing about, as the statute in Fialo, who is admitted in the country and who is not.
Section 1326, I think that's absolutely correct, Judge. I will say that on Fialo, it does not shy away from what it is doing, Fialo. Fialo says, yeah, maybe the dissent is right. In other contexts, because this is a sex-based discrimination, we may apply intermediary scrutiny. But here we don't, and it references Mandel, which was a First Amendment case. Same thing, typically a higher standard of review applies when there's a First Amendment challenge. Not so in the immigration context. Our point, at the risk of making too neat a syllogism, is that an Arlington Heights challenge fits more neatly within those than within the other camp. I do want to return to Arlington Heights. As I understand the duty to purge theory as it's promoted on the other side, it is one that, in our view, misreads Abbott and severely overreads Ramos and Espinoza, and attempts to make comments in the concurrences in those latter two opinions into law. I think, as Judge Sykes correctly pointed out, that's very much not the case. Here's a distinction that seems to be very important in their view of this duty to purge theory, and that is whether a law is a new law or a reenacted law. I believe Mr. Chemerinsky was about to reference in his comments earlier page 665 of the Senate report, and he's right. There they do use the word reenactment in conjunction with the reentry law, but here's the problem. If you read the full sentence, it starts with, "it was commented." That passive voice indicates that what the Senate report is doing there is referencing comments it received during its work in promulgating the report. Here's what actually happened, though, just like in Abbott. Section 1A and Section 2 of the 1929 Act were repealed, just like in Abbott. That's at Section 403, subsection 30 of the Immigration and Nationality Act. Just like in Abbott, we have a law that was repealed and a new law took its place. This is not in the record, but I will tell you I ran a red line between Section 1A of the 1929 Act and Section 1326 as it was in 1952, and you will see a lot more changes than you will see similarities. As this court knows, I believe the point was made earlier, the crime for which defendant was convicted here was not even a crime under the 1929 Act. In circumstances like that, where Congress repeals the old law and makes a new law, Section 26 has greater reach in some respects. It adds the found in clause. It prohibits collateral attacks by removing the in pursuance of law clause, as well as creates exemptions, among others, that authorization can be sought prior to reentry. In a case like that, with a very new law and the old one appealed, Abbott is crystal clear about what matters, and what matters is the intent of the 1952 Congress in enacting the Immigration and Nationality Act.
So with regard to that, that's a good segue to looking at the comments of the various legislatures that the appellant relies on. The district court and the government found in the district court, the government argues that we only have 4 legislatures here. They're talking about this. And I guess my question, I have a couple of questions. One is, well, how many is enough? And 2 is, presumably, of course we have to rely upon the words of legislatures because, you know, whether it's in the report, a written report, or what have you, it's their words. And so just as a matter of kind of foundational premise, you have to look at what they say, what they write, and how they debate. And so I guess goes back to, circling around to my first question, is how are we then supposed to tell the intent of the legislature, right?
Yes, Judge. I think the cases are fairly clear that the best place to start is the congressional records and the Senate reports. Now, I understand that there are more than a few offensive remarks that I don't intend to defend because I can't.
Could you speak up a little?
Oh, I apologize, Judge Flom. The congressional record and the House reports and the Senate reports are the best place to start. It's important to remember that what is key under Arlington Heights is that the discriminatory intent be a motivating reason for the legislation. Well, where would that appear? It would appear, of course, in those two sources. Here we have those reports, and they say nothing of discriminatory animus against Latinx individuals. Instead, they lay out what are the very obvious policy reasons to have teeth to your deportation orders, unlawful reentry prohibition. I think we sort of have two problems here when it comes to the comments that have been pointed out by the other side. The first of which is it is just a handful. Under O'Brien and other cases, that doesn't cut it. This isn't interpreting legislative intent when doing statutory construction. O'Brien's clear about that. To say that a Congress acted with animus is a whole nother ballgame, and 5 legislators is not going to cut it. The other problem we have is that, yes, these remarks were racist, but none were in connection with respect to what became 1326. And Brnovich is clear about the effect of a different legislature. That's a different issue. But other cases like Regents, most recently, is very clear that, things happen outside, not saying one way or another, but for a challenger to a law to use extraneous comments to challenge what is a facially neutral and very sound policy decision to criminalize reentry is too far under Arlington Heights now.
I guess, we're talking about the comments made during the passage consideration of the anti-harboring statute. And my question is, one of the arguments the government makes that we shouldn't give much weight to the racial animus of the 1929 Congress is that there was a big turnover of people, right? And so why isn't the converse true? If there is no turnover of people, in other words, if it's the same Congress, and the same Congress, when discussing a bill that was enacted only 3 months before this one, exhibits indications of racial animus towards Mexicans, then why isn't that at least relevant or probative of something that we should consider when considering whether that same Congress was motivated by similar racial animus when enacting 1326?
Judge, I don't think we resist that it's relevant and it's something you can consider. I think the problem is that it's so disconnected from the 1326 statute that again starts with the 81-15-15 Senate report, that it just says very little about why Congress enacted this particular provision. Our brief sets out why, as offensive of a name that is, the upshot of that law was not one that sort of, if it were subject to its own Arlington Heights analysis, we think would pass muster, and obviously that's not this case. I do just want to note also, Judge Lee, we do not agree with the district court's finding and other courts' findings that the 1929 law was passed with racial animus. We don't think it, again, if this court were to, if that were the law that were being challenged, that it would pass muster. That's, of course, not this case, and this court can do what the district court did and either find that it is or it isn't, and then move on and give it what, under the Supreme Court's precedent as they framed it, gets very little probative value in deciding the intent of the post-war veto overriding 82nd Congress and their passage of the Immigration and Nationality Act.
So you disagree with Appellant's counsel that whether or not the 1929 statute was motivated by racial animus is an undisputed issue?
Correct. It is disputed in this case. Your Honors, I'd like to just address 2 final points. I understood Mr. Chemerinsky to reference that we have a pattern today of 99% of prosecutions being against those of Latinx background, and that is so stark under Arlington Heights that it's unconstitutional. That is a reference if you read Arlington Heights. Arlington Heights calls that an unusual exception. It almost never comes up. It's a reference to Gabellion and Yickwo. That is not how this case has been argued to date. And when to put it mildly, this case is not like those cases. Yickwo, for example, involved laundromat ordinances in Northern California. People of Chinese descent got none. Nobody else had a problem getting any. So there you have your numerator and your denominator, and you can conclude it is so stark. That is a new theory in this case that this court need not weigh in on. I would also note...
Well, we also have no contextualizing record evidence here for that statistic.
Exactly correct, Judge. As the district court said, we lack a comparator. You could also call it a denominator, as I just did. Unless there are any further questions from the court, we would ask that you affirm the district court and the defendant's conviction.
Thank you. Rebuttal.
I would make 2 points by way of rebuttal. First, strict scrutiny is for criminal statutes, even in the immigration context when they're alleged to be racially discriminatory. The cases opposing counsel refers to, Matthews versus Diaz-Mendel, were not race discrimination cases, and the Supreme Court, in its most recent addressing of the topic, the Department of Homeland Security versus Regents, University of California, in this 140 Supreme Court, page 1915, made clear Arlington Heights is used even in the immigration context. The second point is that there is sufficient evidence of discriminatory intent under Arlington Heights. We could certainly go back to the legislative history of 1929. It's described in pages 8 to 14 of our opening brief, but a great deal of the focus now is on the 1952 statute. And here I very much disagree with opposing counsel's characterization. He says that the reports don't say anything with regard to race. Your Honors, I would direct you to Senate Report 81-1515 at pages 577, 579, 580, 584, 585, and 586, all of which you see expression of the same racist motivations as in the 1929 statute. He says it's only a handful of legislators. Here, I'll go to Judge Lee's question of what's enough. The district court said just 4, and a reply brief we say, but there's many more than that. It includes the sponsor of the bill, Senator McCarran. It includes legislators such as Senator Walter George, who said, quote, "The goal of the statute is to preserve the homogeneity of the American people." This should be enough in the context of Arlington Heights to show a discriminatory intent. This is especially so in the context of a law that's a reenactment from what was in 1929. I pointed you to the language of the Senate report that said it's a reenactment, but also from the congressional record. And this is from 98, page 4441. It says that the 1952 law is, quote, an attempt to codify and clarify existing law. It, quote, reiterates existing immigration policies. If you were to compare the 1929 and the 1952 law, what the 1952 law is make the 1920 law stricter. It, for example, was under the 1929 law have to be proven that somebody illegally crossed the border. Under the 1952 law, all that has to be proven is they're found in the United States. The 1929 law applied only to somebody who was deported. The 1952 law also applied to someone who was denied admission.
Mr. Chemerinsky, I think you're referencing in part comments by Representative Yorty and McCarran.
Yes, Your Honor.
And I think the Deputy Attorney General, Peyton Ford. Peyton Ford. Now, are we to take from which none of those comments I read as specific to 1326? So, for 3 officials, one of which is not a member of the Congress, to make those comments, we should impute to the entire body of another Congress. Yeah, Congress as an institution continues, fortunately, since the time of the Republic. But we number the Congresses by different numbers every 2 years. So it's not the same Congress in 1952 that there was in the 20s. So how do we link comments that are not necessarily representative of a majority? How can we read into it a majority of the Congress of the 52 as having an intent? I mean, It's a little bit of a stretch, it seems.
No, Your Honor. Arlington Heights does not require that there be a showing that a majority of the legislators expressed a racist motive, because if that's the test, it will never be met. Arlington Heights says, and I quote, it has to be a motivating factor. And what I focused on is Senator McCarran, who was a sponsor of the 1952 law, Senator Walter George in 1952, the Senate report that preceded the 1952 statute. Now, I think the 1929 law is crucial because the issue is, did the 1952 statute purge the taint? But even the 1952 statute, on its own terms, had a racist motivation, and that's where the district court failed. I see that I'm out of time. Thank you so much.
Thank you very much. Our thanks to all counsel. The case is taken under advisement. We'll move to our second case this morning. Felix Franco and Franco Express versus Richland Refrigerated Solutions. Is it Guyon?
Good morning. May it please the court and counsel. My name is Emmanuel Guyon, and Judge Flom, can you hear me? I have a soft voice. I know you mentioned to the other fellow that can you hear me?
Yeah, I can hear you
okay,
fine.
Okay, I'm sorry. I just want to make sure.
Spoke a little.
Pardon?
Yeah. Those instruments only record; they do not amplify.
Okay.
So this is a large courtroom. So it's important for advocates to speak up.
Okay, thank you. I know you're familiar with the facts that I said in the brief, and I'm not going to go over them. But preliminarily, what I want to say is that there basically are two cases before this court. The plaintiff says the injury that he received on April 10th of 2019 came from the events where he was sleeping in this reefer, this over-the-road tractor, and was struck from the rear, ejected, fell down, hit the dashboard, and then was impaled on a three-point corner of a refrigerator that caused the problems with his back. The defendants tried this case on the basis of a pre-existing condition of neurogenic claudication. And that's a fancy term for the foramen is the opening in the spine. The nerves are in the foramen. And over a period of time, there's a growth in the bone structure called lamina. And if it gets too close to the nerves and people move, and when you get older, that evokes a pain response. So we have two different theories of the case. Mr. Franco was a truck driver for 32 years, starting in 1989. In 2017, he was getting a little bit of a backache. So he went to his primary care physician and said, my back is hurting. The doctor said, well, look, take this Tramadol whenever you need it. So he did. It was it wasn't a prescription regular, but whenever you needed it. And the way he conducted his business, he would leave my hometown of Streator, drive to Green Bay, Wisconsin, pick up cheese, go to Houston and Uvalde, Texas, take cucumbers and tomatoes to Green Bay, and he did that route for many, many years. He also, when that wasn't available, he got to the...
Mr. Guyon, if I could interrupt. We've reviewed the briefs and we're aware of the facts as they were litigated at trial. And this was a causation case, it's clear, and it was submitted to the jury as such. And so it would be helpful if you would identify what error you're resting on in the district court, because the jury found against you that there was no causation here, and that was the end of the case.
Thank you, Your Honor. What happened, he was ejected from that reefer on April 10th of 2019. He sought medical advice and was told that they would try conservative treatment, but if it didn't work, he'd have to have an operation. And that was this translumbar intervertebral fusion. And that eventually happened where he had to do that. They had to do the surgery. When we had the trial, at the end of the evidence, I filed a written 50A motion asking the court to direct the verdict for plaintiff. The court did not act on it. The jury adjourned, went out, came back, no award. So then I filed a 50B motion. The judge ruled on both of those at the same time and said I failed to recite the defense to the action of the 410 when Mr. Hussein rammed the back of the trailer and caused this ejection. But then the defense got up and said they filed a motion for directed verdict. So what I was, if I was deficient, the defense provided the information so the court would rule. He still denied the 50B motion. Now, Your Honor, to answer your direct question, I think the manifest way of the evidence is in favor of the plaintiff. The court should have directed a verdict, and I think it was error to do so. And I think the court caused a lot of problems with the jury instruction. I submitted a special verdict form that at the pretrial conference, and the judge did not want to use it. He declined. He had his own form, which is similar, but a little bit different. And at the instruction conference before the jury retired, judge gave conflicting instructions. He said, on the first day of trial, he told the jury that the defendant had been admitted liability to what? The 410 events or to the 32-year accumulation?
Actually, there wasn't an admission of liability. There was
Okay.
an admission
He
of
also said-
negligence.
Pardon?
Causation was the issue, again, at trial, causation and damages.
Okay. He also said that the defendant was liable. The court said that to the Benard. But then when he gave the final jury instruction, he said he talked about a cause and used it in the singular. But the actual instructions, he started talking about there could be other causes. Well, what could be the other causes? It could only be that neurogenic claudication. And I think that confused the jury. mean,
I
how
did
could-
not see an instructional error claim in the briefs. The instruction that the court gave on causation was textbook Wisconsin causation law.
Okay. I think the jury was misled though, because he was telling them two different things. I know we have to use
In
standard
what-
instructions, but
In what way?
because it started out by saying the defendant was liable for what happened, and then he said that there could be not only a cause, but there could be other causes. What could be the only other cause? Was a 32-year neurogenic claudication problem.
Mr. Guyon, can you point me, and perhaps I just missed it, can you point me in the record where the judge instructed the jury that the defendant was liable for what had happened?
In the introductory, I do have it, I think, attached to the main brief. I copied the transcript. I don't have it in front of me, but there is, he said that. He said that defendant is liable. The court said that. Liable for what? The 410 events or for the 32-year developing condition of neurogenic claudication? I don't see how anybody could hold him liable for, or how he could admit liability for the 32-year thing. It had to be for the 410 events. And I think that confused the jury. As far as proximate cause is concerned, in my final argument, I made the comment about finding proximate cause, which again came out of the jury instructions.
Actually, wrong.
Really?
Yeah.
Okay.
Wisconsin doesn't treat proximate cause as a jury question for the court. In fact, doesn't use the concept of proximate cause. Wisconsin follows the Paulsgraf dissent for negligence law and causation.
in
So
my
there's
reply
cause and
brief.
fact, and there's legal cause, and the court addresses the question of legal cause, not the jury. That's why your argument was about proximate cause was excluded,
Well-
because that's not a concept that goes to a jury in Wisconsin.
But if I was wrong about that, it was corrected by the judge then, right? Give me-
No, proximate cause is not a proper causation principle under Wisconsin negligence law. Long line of cases.
The judge
Wisconsin
said-
follows the dissent in Paulsgraf,
Your Honor,
not the majority opinion.
Your Honor, the judge said, I'll handle proximate cause.
He said
that's-
proximate cause is not an issue here.
Okay, all right.
The court handles questions of legal causation as a matter of public policy.
The medical evidence, Dr. Bauer, the respondents, defendants, medical expert, said the surgery was done only for the neurogenic claudication. Dr. Weiss, preparatory to the to the operation that he was going to have the TLIF installed, they did an MRI, and he very detailed the neurogenic claudication in the plaintiff. 6 months later, he had the surgery. 5 months later, he did another MRI, looking at the neurogenic claudication. The medical evidence in both cases shows no change in the neurogenic claudication. So when Dr. Bauer says they did the operation only for the neurogenic claudication, it's exactly the same 7 months before surgery and 5 months after. So the surgery had to have been done only for installing the TLIF, trying to correct the problems from the events of April 10th of 2019. That's all I have to say. If you have any questions, I'll be happy to.
Thank you.
Okay, thank you.
Mr. Is it Cuisinart?
Yes,
Cuisinart,
Your Honor.
thank you.
Francis P. Cuisinart, I go by Pat. May it please the court. This was a 3-day jury trial tried on diversity jurisdiction applying Wisconsin law. Defendant admitted negligence. The jury was asked to decide whether the accident on April 10, 2019 was a cause of any injuries that led to plaintiff's back surgery 2 years later. This case arose out of a low-speed motor vehicle accident. The plaintiff did not complain of any injuries at the scene. He continued to drive down to Texas, and over the next 2 years, he continued to operate his business as a truck driver, driving regularly.
My understanding is the jury was out 10 minutes.
The jury was out 10 minutes. I would, you don't want to speculate, but if they had some questions, normally a jury will ask a question of the court, can you clarify an instruction? There was no question. They came to their decision right away. I don't know what else to say other than this was a classic jury question. You had 3 highly qualified doctors who specialize in complex spinal surgery. 2 of the doctors, Dr. Din, the treating doctor, and Dr. Bauer, the defendant's retained expert, were of the opinion that the plaintiff's condition was entirely degenerative and he would have needed this surgery regardless of the accident. Dr. Alexander Ganayam, the plaintiff's retained expert, disagreed. He was of the opinion that the accident was a contributing factor. Again, this is a classic question for the jury to decide.
Counsel, did the judge, Mr. Guyon says the judge told the jury that the defendant did not contest liability or had admitted liability. Does that appear anywhere in the record?
Your Honor, I think
I know that
there was a statement to that effect, but it has to be taken in the context, and I can read you the entire statement. In the preliminary instructions to the jury, the judge stated, Richland admits that its driver was negligent in hitting Franco's truck and that Richland is legally responsible for the negligence of its driver, but the parties dispute how much Franco was injured in the accident. Franco alleges that his back was injured by the accident, requiring surgery and preventing him from continuing his job as a truck driver. Richland alleges that any injuries to Franco's back existed before the accident and were not aggravated by the accident. You will not have to decide the issue of liability in this case. Plaintiff's only claim against Richland is for negligence, and as already noted, Richland concedes its driver was negligent. Your job as jurors will be to decide what damages, if any, Richland's driver caused plaintiff to suffer. That's in docket 157, page 47. So in that context, my suggestion to the court is those comments were perfectly consistent with the jury instructions the jury was given at the close of the evidence. The jury instructions quoted from, basically paraphrased, the Wisconsin Supreme Court in the Emrys case with regard to causation.
Well, it might have been helpful if the judge had mentioned that causation was the focus of the trial, not just damages. But, you know, that's not a reversible error.
Well,
I mean, the judge didn't
I agree. I mean,
explain that there's an additional element to liability, and that is causation, and was the entire focus of this trial,
Yeah.
as I understand it.
and it was the focus of the closing argument. It certainly was my closing argument.
And the focus of the jury instructions and so forth.
Yes, yes.
So,
I mean, the bottom line is under 50A and 50B, the court addressed those, the two motions, and the court concluded that he acknowledged that there was evidence presented on behalf of the plaintiff to support his claim on causation and damages. But the court indicated that the plaintiff disregarded the abundance of evidence that the defendants offered to the contrary. Again, that's a classic jury question, and there's no basis to rule as a matter of law, to grant judgment as a matter of law under those circumstances. The jury was not confused based upon the two instructions that I just alluded to. The final instruction, I won't read it to you, but if you want me to read it to you, I will. But it was perfectly consistent. The jury didn't ask any questions, and it was out for 10 minutes. I think it's mere speculation that the jury was confused. Counsel mentioned in his brief, that he was unfairly prejudiced by the judge's refusal to allow two demonstrative exhibits. At the pretrial conference, the plaintiff showed the judge 4 diagrams of the human spine. The judge indicated he would show the jury 2 of the diagrams. There's no medical testimony why the other 2 had to be shown to the jury and why it would have made a difference in the case. Obviously, it didn't make a difference because they were out for 10 minutes, and I doubt whether they even looked at any demonstrative exhibits during that 10 minutes. Your Honors, if there's any questions that you have, I will try to answer them. Otherwise, I'd ask that you affirm the verdict of the district court and the judgment of the district court.
thank you.
Thank you.
Anything further, Mr. Guyan?
Your Honor, again, the collision was on 4/10 of 2019. While he was driving his truck, completing his job obligation 3 days later, he had to stop and lay on the floor of his truck because he was in such pain. And then a similar incident happened in May of 2017. I think that's close enough that there's a causal connection as to what happened. Dr. Ghanem, who's the chairperson of the Department of Orthopedic Surgery, a spine surgeon, said that the surgery that was done on Mr. Franco was correct, and that was the proper way to correct the problems that he now has. And it hasn't turned out as well as it should, but it's the best they can do with the technology they have today. So if you have any other questions, I'll be happy to answer. Thank you.
Thank you. Our thanks to all counsel. The case is taken under advisement. And before we call our third case, the court will be in recess for a few minutes. right, thank you, everyone. Our next case for argument this morning is Capitol Street Surgery Center versus NLRB. Mr. Guevara.
Yes. Good morning, Your Honors. Greg Guevara on behalf of the respondent, Capitol Street Surgery Center. May it please the Court. The lesson of this Court's decision in the Sears-Roebuck case is that the facts matter. To survive scrutiny, the Board's findings of fact must be supported by substantial evidence. The findings cannot be grounded in speculation or conjecture, they cannot stretch the evidence beyond reason, and they cannot simply disregard or discount evidence that supports a contrary view. Yet that's exactly what happened in this case, Your Honors. According to 7 witnesses called by both the respondent and the general counsel, Mr. Louster had an extensive history of unprofessional conduct during patient procedures, including not paying attention or becoming easily distracted during surgeries, not anticipating the needs of the doctor, not listening to the doctor, not following the doctor's directions, squirting coworkers with saline, doodling on the scrub tray with markers, and poking nurses with his fingers, talking excessively, goofing around, carelessly dropping lines and other supplies, and not setting up the room correctly for standard procedures. On November 18, 2020, lead tech Lozano reported to Administrator Brandon Arrett that Mr. Louster had set up the surgical field for a procedure incorrectly and that it had to be corrected while the patient was already on the table.
Mr. Guevara,
Yes, Your
kind
Honor.
of taking a step back,
Yes.
can we talk about standard of review?
Yes.
You argue that the court should not give any deference to the fact finding of the NLRB or the ALJ. And you make the argument, but I'm wondering, can you cite to any Supreme Court or Seventh Circuit law that would support such an argument?
I cannot, Your Honor. What I can say is that there is board case law that suggests that it's appropriate to do a de novo review when there is no, the judge in this case, the ALJ, had decided the case on a paper record. And so we feel that that's why a de novo review would be appropriate. But, Your Honor, my entire argument today is based upon substantial evidence.
Well, and
Yes.
the judge who presided at the trial when the witnesses actually testified did so virtually and then left the bench.
Correct.
Left, the agency bench.
That's correct.
And that's why it was referred to another judge for a paper record review.
Correct,
And
Your Honor.
I understood your argument to focus mostly on the credibility determinations that have been made by the successor ALJ.
We did think those were significant, yes.
And
Yes.
the case law gives great deference to credibility findings, and I understood the argument to encompass a subtler point about whether this is a substantial evidence case or a de novo review. Clearly, substantial evidence is the statutory standard of review,
Right.
and to fit your argument within the statutory framework for all agency review, it's a question of what level of deference is owed to credibility findings when they're made based on a paper record. Do they get the same sort of deference on steroids that a
Right.
credibility finding with live witnesses and a judge in the same room would get, or do they get less than that?
And I think that's a fine point, Your Honor. And the reality is, in this instance, that there were so many leaps of jumps of speculation and conclusions that were just grounded one upon the other, and that's what I wanted to talk about. That specifically, the judge just kept going and going and going and finding every single inference against the employer and just looked at just disregarded the testimony. I just gave the example of the 7 witnesses who testified about this long pattern of history, which created the context for the decision itself. When Mr. Arrett, when they came in and said, hey, he was messing around again, he's handling a flashlight during a procedure, which the judge said wasn't even an offense. It wasn't even an offense. He's handling an emergency flashlight. There's no clinical reason to do so. That's undisputed. There's no basis there's another group at the sterile processing department that's responsible for actually managing those flashlights. And yet he's manipulating a flashlight while the patient's on the table, and he's pointing it toward a nurse who's monitoring the patient's vitals. So
we have a threshold problem before we even get to any of that about whether the decision maker here actually knew about the protected activity by
And he
Mr.
did not.
Louster?
He did not, Your Honor. He did not know because the judge found that he knew because he had, in a one sentence, he was asked the question, did you find out about what happened in the meeting? And he said, yes, I talked with Danielle Mahindra about the meeting. It was a 2-hour inventory meeting.
With how many agenda items?
With 13 or 14, I don't remember. The last agenda item was the one. It was all about inventory. And he testified that he didn't know anything about what any of the specific text said in that meeting, certainly did not know anything about what Mr. Lauster said in that meeting, and yet the judge specifically found that testimony, even though it controverted his direct specific testimony, that testimony was sufficient to establish that he knew that Mr. Lauster had been the primary instigator. On that point specifically, the judge found that Mr. Lauster, that he initiated the objection and that he said that a nurse operating the C-arm would be illegal. That's false. That's not what the record says. What happens is Dr. Mahindra said, can Chelsea run the C-arm? And Mr. Lauster said, no, she's an RN. That's it. Then another IR tech says, actually, it would be illegal because that's the job of the IR techs. So Dr. Mahindra initiated the conversation, and another IR tech made the comment it would be illegal. The judge said that he did both of those, that Lauster did both of those things, and that's why Mr. Ehret was motivated to terminate him based upon something that he didn't even know that the conversation had happened.
Right, and I understand that, and this is a factual argument, but I have a predicate legal question
Sure.
about how it is that Mr. Lauster's response to Dr. Mahindra's question about whether Chelsea could run the C-arm, where Mr. Lauster says, no, she's an RN, constitutes protected activity as a legal matter under the statute. I know that was stipulated or agreed, and I don't understand how it fits within the definition of concerted activities for mutual aid and protection of the employees.
We didn't challenge that point at trial or at the board level, Your Honor. We're not challenging it here. In essence, if it were protected, there were multiple people in that meeting that had that same conversation and that talked about that topic. And at the end of the day, the only person who was discharged was Mr. Lauster, who had this extensive history of screwing around in the operating room and had one more report that that's what happened. That's what actually happened.
With regard to Mr. Ehret's knowledge, I think in the transcript he did say that as a general matter when he was asked, well, when you're not at a meeting, don't the lead IR techs report what happened at the meeting? And they asked him, well, do they also report the questions that came up in the meeting? He said, as a general matter, they do convey to me questions that came up during the meeing.
Sure, and that may be a standard practice in a 2-hour inventory meeting.
And I guess my question is, wouldn't the discussion with regard to the CR arm generally, and I know you're going to say it's not particularly Mr. Lauster, but with regard to the questions that were raised during the CR arm, wouldn't you expect Mr. Ehret to at least be informed that, hey, there's a question about this practice that you're proposing?
I would think it could have happened. There wasn't testimony that it did, but I think the key, Your Honor, is that it would have had, in order to create the motivation, the animus against Mr. Lauster, Mr. Ehret would have needed to know that Mr. Lauster was somehow in a different place than the rest of the IR techs in relation to this conversation. And the record doesn't reflect any differentiating factors that would put him at risk. What it does reflect is that, and the judge literally ignored the testimony of two neutral witnesses, two nurses who came in and said, he's highly distracting, it's very disruptive, he pokes us while we're trying to get our job done. And that's the context of what actually happened. And this is really ultimately about the surgery center's ability to protect its patients and to make decisions about what's in the best interest of its patients. So, Your Honor, I'm going to reserve the rest of my time. I've only got 45 seconds, so I'm going to hold that. Thank you.
That's fine. Thank you. Mr. Seid.
Good morning, Your Honor. May it please the Court, David Seid for the Labor Board. Substantial evidence supports the Board's finding that the company unlawfully discharged employer Lauster Before the court, the company has not shown that the record compels a different result. The company's argument relies primarily on discredited testimony while ignoring the credited testimony, and has not offered any basis to overturn the administrative law judge's very well-reasoned and very detailed credibility determinations that encompass almost 3 pages of his decision that were then reviewed de novo by the board. With respect to the discharge, I do want to clarify a couple of points. First and foremost, the company acknowledged, and this is Administrator Earhart at Supplemental Appendix pages 91 and 93, that the basis for the reason he was discharged was allegedly making wall puppets with a flashlight. Very simply, the board, based on the credited testimony, found that that incident simply did not exist. It's addressed in detail, obviously, in the board's decision and in the board's brief, but just very briefly, Nurse Filu was reasonably credited as an existing employee who was testifying against the company's interest, that it simply did not happen, and that it would have been too bright in the room for it to happen, and reasonably discredited Supervisor Lozano, whose testimony, quite frankly, was all over the place. She initially testified that the incident was so distracting and so bad that Mr. Lauster actually left the CR machine and that Supervisor Mahindra had to step in and run it. She then acknowledged later on in her own testimony at Supplemental Appendix page 546 that she wasn't even sure that Supervisor Mahindra was even in the room at the time. And then when Supervisor Mahindra had testified about the alleged incident, she couldn't recall any of the sort happening and didn't say anything about having to take over the CR machine. As far as Mr. Lauster's overall work performance, very simply, again, the company—
I'd like to focus on the threshold question of Mr. Ehret's knowledge of the protected activity at issue here, which is the single comment by Mr. Lauster in the 2-hour meeting answering Dr. Mahindra's question about whether Chelsea, the nurse, was authorized to run the C-arm.
Yes, Your Honor, knowledge can be inferred from all of the factors. And here I would point out it wasn't just one comment, the no. He then proceeded to state that the nurse was not qualified to run it or wasn't licensed to run it. And then there was a third comment that was also made a little bit later on. But as far as inferring the knowledge, this was an item that Administrator Earhart himself, the morning of the meeting, placed on the agenda. And there were 7 agenda items. This was agenda item number 6, that he very specifically, in the morning of the meeting, placed on the agenda that the nurse who is not licensed to run this machine would be running it instead of giving overtime to those who were qualified to run it. And the board reasonably inferred, given Earhart's own testimony, that he is normally told what happens after the meetings, that he was specifically told about this meeting after the fact, that he would not be told anything about an agenda that he placed on the meeting that really led to quite an uproar and an opposition.
But there was no competent evidence, no evidence at all that he was told about what transpired on that particular agenda item. All we have is his testimony that as a general matter, his representatives in meetings like this, the lead IT techs, report to him on what happens during meetings. That's creates nothing more than speculation that includes this particular agenda item when there's no affirmative evidence suggesting that he was aware and was in fact told about what Mr. Lauster had said.
Your Honor, I would respectfully disagree with the suggestion this is simply speculation. It's a reasonable inference.
Well, is there anything more than his general statement that my lead IT techs report to me about what happens during meetings? Do we have anything more than that?
Well, that the supervisors report to him. He acknowledged getting reported to after this particular meeting, and he's the one that the morning of the meeting places on the agenda that employees are being
Well, we understand,
told.
yeah. It's
and
clear
so
that he put this item on the agenda, but there's no affirmative evidence that anybody told him what transpired on this agenda item. It's the inference that you're asking us to approve of that was drawn by the ALJ here, who didn't hear any of this testimony but decided the case on the paper record, that the inference rests solely on that general practice, that he's generally told what happens at meetings, and that he did receive a report at this about this meeting. Nothing more than that supports this critical element of knowledge, which is essential to liability, because the termination decision, the firing decision, had to have been made because of his protected activity, that was a substantial motivating factor.
Your Honor, I understand the court's concern, but would simply, and I don't mean to be repetitive, but that simply because the two supervisors denied telling, and their denial wasn't simply that they didn't tell Administrator Earhart about the whole discussion that took place regarding unlicensed people using the C-arm and overtime, or the lack of overtime, but that they didn't even tell him anything, not a single word about this whole issue that he had placed on the agenda. And in that context, the administrative law judges upheld by the board very reasonably discredited that testimony and inferred that, come on, you must have told him something about this agenda item that he himself had placed on the meeting for that day.
Mr. Seed, could I tell you what gives me some pause in this case? We have to give substantial deference to the finding, but you've got a judge making credibility decisions off a written record. The judge who tried the case never issued an opinion. Kind of an unusual situation. This isn't like a judge coming in a criminal case where the judge tried the case and another judge does the sentencing, because you have a unique separate hearing where that judge can make that kind of independent judgment, the second judge. Here, how much deference should we give to a judge who can't read the record any differently than I could read the record?
Your Honor, I would simply direct the court to its decision cited in the board's brief, the Sioux Products case, where the court recognized that though a determination of credibility was not based on demeanor, that it was still, and it wasn't necessarily entitled to exceptional weight, the credibility determinations nonetheless should be upheld where the administrative law judge did provide a basis and explanation for making those decisions. And again, there's almost 3 pages of the administrative law judge's decision where he is exhaustively going through the testimony, pointing out the inconsistencies, drawing reasonable inferences, and ultimately deciding which testimony should be credited and which testimony should not be credited. And that was certainly very reasonably done, and the company has not shown any basis.
How long did this hearing take?
The hearing, Your Honor, I don't recall specifically how long it took. It's about a 700-page record, whether it's over a couple of days.
Well, how often do we confront a situation where the ALJ leaves the case and never issues an opinion, and then we're asked to look at the work of the second judge who just reads a cold record? I don't recall having faced such a case, but I'm sure there may have been one.
Your Honor, I can't point to a specific case where a judge has left a case. This is a situation where apparently the judge left the agency, and that's why the judge was not able to write the decision. But as indicated in the Sioux Products case, there are certainly situations where administrative law judges issue opinion where they make credibility determinations that are not based on demeanor. And again, while this court has indicated they may not be entitled to great weight, as long as the judge, and as upheld by the board, provide a reasonable explanation for those credibility determinations, they should be upheld. And that's certainly the case here where, again, there's multiple pages of going through.
Mr. Seed, I guess, when I look at, one of the things that gives me concern is that it seems like one reading could be the ALJ just, and I think the ALJ says this, basically says, I don't believe any of it. He basically says, look, from what I've seen, I don't believe anything that Earhart, Mohindra, or Lozano says. And he says that, and to some extent, he doesn't address some of the key reasons that would be contrary to that, to his kind of overall analysis, right? So one of the things that Appellant's counsel points out is, the various witnesses talk about Mr. Lauster's prior record problems at the OR, including, I think it's Ms. Hunter and Ms. Habert. And it seems to me that one can surmise that one of the reasons the ALJ didn't do it is because the ALJ made up his mind early on and said, you know what, I don't believe these folks, and so I'm not going to deal with everything, the entire substance of their testimony. I'm just going to flat out disregard all of it. To me, that doesn't seem like a very reasoned opinion, particularly when the ALJ doesn't wrestle with directly contrary evidence.
Your Honor, I see that my time is up. 2 points. First, if the reason for the discharge simply did not happen, and again, it is absolutely undisputed in this case, that Administrator Earhart made a decision to discharge employee Lauster based on the alleged incident with the flashlight or making the puppets on the wall. If that didn't happen, the company can then not come back and say, well, there's really other reasons or other things that happened. And then also to just show really the just outright at times ridiculous testimony from the company witnesses is that Administrator Earhart claimed that Mr. Lauster was put on a performance plan. But then at the hearing, he testifies at page 585 and 86, it wasn't put in writing, and Mr. Lauster was never even informed that he was allegedly put on a performance plan. So it's testimony like that, and again, this court should not engage in de novo review, but it's welcome to look at the entire record and just see time after time after time of company witnesses literally tripping over themselves with inconsistent stories and backing up on certain things that they say at one point, like again with the wall puppet happening, and then the very person who supposedly saw it basically claiming, well, it may not have really happened the way I said it happened.
All right. Thank you very much.
Thank you, Your Honor.
Your
The court
time
would
has
simply
expired.
ask that the court enforce its order.
Mr. Corvar.
Your Honors, if anyone was tripping over themselves in this case, it was the ALJ to find literally every single credibility determination adverse to the company, adverse to 7 different witnesses, including some called by the general counsel herself. Even the idea that he was given, Administrator Arrett testified that he had spoken with Mr. Lauster repeatedly about these issues. Ms. Lozano and Ms. Mahindra had also spoken with him. So he was on notice. The judge said, well, he hadn't been given a formal written warning. Neither had the other 2 employees that were summarily terminated based upon safety violations. That's just the way the company did it, and there was nothing that required them to do it differently than that. He was an at-will employee. They made a business decision based upon what they felt was in the safety of their client, of their patients, and in the best interest of the company, and did not do so in a way that had anything at all to do with statements that Mr. Lauster made about which Mr. Arrett knew nothing. We'd ask the order to be unenforced or not enforced.
All right, thank you very much. Our thanks to both counsel. The case is taken under advisement. And we'll move to our 4th case this morning. Jennifer Shirk versus Indiana University Board of Trustees. Ms. Conklin.
Good morning. May it please the court, Anna Conklin for the plaintiff appellant, Jennifer Shirk. Jennifer Shirk has presented ample evidence to create an inference that her termination was retaliatory. First, Ms. Shirk presented evidence that the defendants singled out her protected activity in her termination meeting. Second, Ms. Shirk presented evidence that they had been actively looking for a way to get rid of her. Third, Ms. Shirk presented evidence that IU instructed an HR person to lie about the circumstances involving Ms. Shirk's protected activity. Fourth, Ms. Shirk presented evidence that her supervisors assumed she couldn't do her job because she requested accommodations. And fifth, Ms. Shirk presented evidence that her supervisors became angry and viewed it as a performance issue that she, quote, disappeared on FMLA leave. Each time she engaged in protected activity, from the time that she complained she was denied a reclassification request because she took FMLA, the defendants reacted negatively. Ms. Shirk presented evidence that a jury could reasonably find that by the time she escalated a concern about discrimination and retaliation that had been ignored at the levels below, the defendants were so fed up with her protected activities that they terminated her employment. The defendants hold out the emails that Ms. Shirk sent on April 15th and 16th as the sole legitimate non-discriminatory reason for Ms. Shirk's termination. But Ms. Shirk presented evidence that 2 other employees who contributed to those emails were not fired. One of them was Ms. Kavanaugh, who, like Ms. Shirk, reported to Mr. Zimliak, who made the decision to terminate Ms. Shirk.
Ms. Conklin, with regard to that, I was looking at the record to ascertain when Mr. Zimliak found out that Ms. Kavanaugh had assisted Ms. Shirk. Can you enlighten me on the timing of that? It wasn't clear from his testimony whether or not he found out before Ms. Shirk was terminated or after she was terminated.
I agree that the testimony is not entirely clear, and from my memory of the testimony, he didn't necessarily know about Ms. Kavanaugh's contribution at the time that he terminated Jennifer Shirk, but the testimony is clear that at some point he did learn that one of his direct reports contributed to the very emails that he says Jennifer Shirk was fired for, and further testified that not only was that employee not terminated, she was not disciplined, and he didn't even have a conversation with her to say, hey, this is inappropriate conduct that my direct reports should not be engaging in. In the due process meeting on April 16th, the defendants singled out Jennifer Shirk's protected activity. Mr. Ying, the HR employee, read aloud the very line of Jennifer Shirk's 3rd email where she alleged she was being discriminated and retaliated against and was raising those concerns. Mr. Ying asked Ms. Shirk why she put that in her email to Mr. Foley. This is undisputed. Then she's told that she's fired for discussing private matters not relevant to services being provided to OOE, Mr. Foley's department, and for sharing disparaging personal opinions of Learning Technologies leadership with OOE, Mr. Foley's department, that threatens client relationships.
Ms. Conklin, assume that the Mr. Ying and the company did not point to that middle email. I understand there's 3 emails, right?
Yes.
On the 16th. Instead, relied only upon the email that she sent on the 15th, as well as the first email that she sent on the 16th. Okay? Would you still have a claim?
Yes, that's the argument that the defendants made at the district court level, trying to separate the first 2 emails from the 3rd protected activity email.
And I know factually they can't. I'm saying hypothetically speaking, let's talk about an alternative universe where that 2nd and 3rd email was not sent. Okay? Would you still have a claim?
Yes, because if you back up before that, former HR employee Jim Peltz is testifying that after Shirk's conversations with management, where Shirk's managers are conveying that Jennifer Shirk is being generally disruptive, IU went looking for a reason to terminate her employment. And then if you look at Mr. Zimliak's testimony about what he thought the problem was with the emails, he testifies that the emails are disruptive. So as you can see, the only disruptive activity that Ms. Shirk could possibly be engaging in is protected activity. That's why her managers are viewing her as a disruptive employee.
I thought they thought she was disruptive because she was sending emails, kind of going over their heads and sending emails directly to their client when that was not really kind of her place or within the scope of her responsibilities to do so.
That's the reason the defendants hold out, but when I asked Mr. Zimliak whether it would be appropriate for Jennifer Shirk to raise a concern if she had an issue with several levels of management to the next leader, he testified that that would be completely appropriate. There's also
But the person to whom, and I'm sorry, I forgot the person's name, to whom she directed the email, he wasn't part of their organization. He was, as I understand it, someone in the other part of the university that was the e-learning group's client, right?
The defendant characterizes him as a client, but in her termination meeting, Jennifer Shirk testified that she didn't understand he was a client. She thought that he was the appropriate person to escalate these concerns to. Her boss's boss also thought this was the appropriate person to escalate concerns to. Her client that she was working for testified in an affidavit that she thought this was the appropriate person to escalate concerns to, and nobody, including Mr. Foley, told Ms. Shirk that he was not the appropriate person to escalate these concerns to. And the standard, Your Honor, on summary judgment is that she's engaging in protected activity when she has a reasonable belief that she's raising concerns and engaging in protected activity under the law, and there's no dispute in the record, Your Honor, that she holds that reasonable belief. I would like to reserve the rest of my time for rebuttal.
That's fine, thank you. Is it Makia?
Excuse me, Makia.
Makia.
May it please the court. Ms. Shirk's complaint against IU originally included several claims, including a disability discrimination claim, retaliation claim, failure to accommodate a disability, and a disability-based harassment claim. The district court entered summary judgment on all of those claims in favor of IU and the individual defendants. Now, these issues have been narrowed on appeal. There are two specific questions. First, there is an FMLA claim brought against Justin Zemlak in his individual capacity, and the question is whether a reasonable fact finder could conclude that Ms. Shirk's FMLA leave caused his decision to terminate her employment. The second question is whether a reasonable fact finder could conclude that IU terminated Ms. Shirk's employment because of any of her protected activities, which were taking FMLA leaves, requesting disability-related accommodations, and making complaints of discrimination and retaliation. The answer to both of those questions is no. There is no causal connection between Ms. Shirk's FMLA leave or any of her other protected activities and the decision to terminate her employment from IU.
So we have a statement by the HR person of the company, saying that these are the emails on which we base your termination. One of the emails flatly raises the issue of all of the objections and complaints she had with regard to the way they treated her and a request for FMLA leave. So just from that alone, why couldn't a reasonable jury look at that and say, well, you know, since that's what the company says, and they asked her about it during a termination or her exit interview, maybe that is one of the reasons.
Sure. So I think the timing is important in this. So the first email, as you mentioned before, was sent on April 15th. And after that email, Justin Zemlak was told about that email, and he said that that is something that it was out of bounds for her to do. He said that in a message to her direct supervisor. And then HR was notified right after that email. And then the second two emails were sent on the next day. Her claim of, or I say, what precipitated the third email is Peter Ermey, her direct supervisor, asked her to send her copies of these emails so that he could see what she had said. And she said in that third email that she feared retaliation as a result of giving Peter Ermey those emails. So this was already on HR's email, or on their radar by the time that that third email had even been sent. And it was already something that there was a lot of concern around why she would involve a client in this sort of internal dispute that was going on with a problem that was ultimately solved very quickly. So then fast forward to the termination meeting or due process meeting, because they hadn't made the decision yet. And Mr. Ying testified that he started this meeting by asking her about all of these emails. What was your general intent? Why did you send these? And it wasn't until she brought up that third email that he then said, okay, fine, why did you ask about this specific, or why did you say this specific thing in your email? And so in his role at HR, now he didn't testify as to why he asked that, as he just said that it was in response to her raising that email during the meeting. But in his role at HR, it would be logical for him to ask why she was sending an email about retaliation in that setting. So she also testified, Ms. Shirk testified, that she wrote that email, those specific words, to Chris Foley so that she, quote, so that she would not get fired out of retaliation. So she tried to insulate herself from the other emails that she sent. But as the district court has said, in this case, the mere mention of discrimination does not pull a blanket of immunity over the entirety of Ms. Shirk's conduct. Otherwise, any employee could shield even the most outlandish behavior by invoking discrimination at the end of it.
Sure, but the relevant inquiry, the salient inquiry, is not why Ms. Shirk sent the email. The salient inquiry is why the employer decided to terminate her. And isn't there a letter from Mr. Ying, or basically saying we're terminating you because of your emails, plural, that you sent on April 15th, and the emails that you sent on April 16th, which presumably includes the email where she is raising the issue of retaliation? Then isn't it just, and you ask us to draw the inference that, you know, that's not really why she was terminated. But isn't that a factual question that should go to the jury and have the jury decide that?
No, I don't think it is, because I don't think that the two decision makers in this, Justin Zemlyak was the decision maker, and he made that decision in conjunction with Chris Ying and his support as the HR person. And their testimony is that it wasn't any complaint of discrimination or any fear of retaliation. That third email also, it didn't just have that retaliation fear listed in it. You know, it was a long email, it was 4 paragraphs long. So it had other things in there as well. So it's not that, so they testified that she was terminated because of these emails being sent. The fact that she put all of these issues with what she said was Peter Ermey's performance, Justin Zemlak's ability to essentially lead his department. She put those at the forefront of a client, and not just a client, but the biggest client and funding source that her department had. And so Justin Zemlyak testified that he talked to Chris Foley, and he was concerned about the email. Chris Ying said that he talked to the other individual on the emails, Ms. Johnson, Julie Johnson, who was Justin Zemlak's direct supervisor, and she also had a level of concern about some of the negative that could happen from these emails. So no, I do not think that it's a question of fact, because I think the record makes clear that it was the act of sending these emails to a client that resulted in the terminable offense. And the fact that this was raised to HR after the very first email was sent, and the fact that Justin Zemlyak in a Slack message, an internal message to Peter Ermey, said that this is completely out of bounds for her to do after that very first email, I think shows that that was the mentality behind the termination decision. So the applicable standard on summary judgment is whether there is sufficient evidence that would allow a reasonable jury to conclude that Ms. Shirk's protected activity caused her termination.
We do have something of a legal debate about the causation standard here. It wasn't mentioned in your opponent's opening argument, but it is briefed extensively here, and whether the district court used the wrong causation standard. As I understand the case to be narrowed on appeal, we have 2 retaliation claims, one under the FMLA and one under the Rehabilitation Act. So it's purely the retaliation causation standard, which is not the sole cause for an affirmative disparate treatment discrimination claim under the Rehabilitation Act, but the but-for causation standard, a substantial motivating factor for the termination decision for a retaliation claim, that the motivation was to retaliate against her because of her disability or FMLA protected activity. When the judge got to the retaliation claims, the decision remains a little muddled, and perhaps you can shed some light on that.
Sure, yes. So he does set forth the proper standards of all of the claims on pages 11 and 12 of his order. But then you are right. There is an area in the court, or in the order, where the court does analyze both the discrimination claim and the retaliation claim under the Rehab Act together, and then concludes that her disability or protected activities were not the, quote, sole reasons of her termination. But even so, it would amount to reversible error, even if he did articulate that legal standard incorrectly. It would amount to reversible error only if Ms. Shirk could also show that summary judgment was unwarranted. And that's what we say she cannot do. Because in the district court's order, it holds that Ms. Shirk introduced no evidence to connect the termination decision with her protected class or activity. And so the court made clear that even the slightest causal connection under any standard was not found, and granted summary judgment on that basis.
I kind of expected you to say that because our standard of review is de novo, we can basically ignore that misstep by the district court.
Well, I do think that because your standard of review is de novo, it's not reversible error. You don't have to remand it back. And I think it's the stronger argument there is that the district court, he did say that there was no connection there. And so if this court agrees that there's no causal connection between the evidence put forth by Ms. Shirk and her termination, then remand would not be necessary here because he did say there was no causal connection. And I see that I'm already out of time, so unless you have any other questions, I'll conclude. Thank you very much.
All right, thank you very much. Ms. Conklin, you had a little time left.
Your Honor, I agree with the defendant's counsel that the timing here is important. Mr. Zimliak is notified of the email and forwards it to HR, but Ms. Shirk is not called into a due process meeting then, not after the first email on April 15th. She sends another email on April 16th, and then an email that is clearly protected activity on April 16th. It is only after that third email that HR calls Ms. Shirk into the due process meeting, which it says was so urgent that it couldn't provide more than 30 minutes notice.
The problem is that this entire email exchange had to do with the funding shortfall in the unit, and she took it onto herself to report that to the top of the food chain, and that was improper, bypassing numerous layers of supervision. And it was only until the very end, when she knew she was in trouble for doing that, that she injects the issue of her disability and hostile work environment as an afterthought, bootstrap kind of a thing. That's a pretty slim read to get to a jury on.
That's one interpretation of the evidence that draws the inferences in favor of the defendant, which is not appropriate on summary judgment.
I'm just looking at the record as a whole.
So the defendant takes out of context Ms. Shirk's quote that she put that in her email so she would not get fired out of retaliation. She was concerned about Mr. Ermey firing her out of retaliation because he's requesting her emails. She's not putting this in her email so that if she gets called into a due process meeting, she's not going to get fired out of retaliation because she used the magic words in her email.
Does that make any sense as an explanation for dropping that completely unrelated issue into an email chain with the top brass?
Jennifer Shirk,
it has to make some sense.
She testified to her reasonable belief that Mr. Foley was the next person in line, and she testified that she had already gone to Ms.
Mr. Foley
Johnston.
is a client, and she's got many layers of supervision above her.
But she had already gone to Ms. Johnston, who was the next level above Mr. Zimliak, and Ms. Johnston told her, I cannot help you because of my interim position. So who else is she supposed to go to? She goes to the person who she reasonably believes is the next person in line. And that reasonable belief, supported by other supervisors below, is what makes her activity protected. Thank you.
All right, thank you very much. Our thanks to all counsel. The case is taken under advisement. And our fifth case for argument this morning is United States against Jameson Crayon Boole. I hope I pronounced that correctly. Come on up, Mr. Lewis, whenever you're ready.
Good morning, Your Honors. May it please the Court. I'm Brian Lewis here on behalf of the appellant, Captain Jameson Crayon Boole, United States Air Force, retired. This is a criminal appeal from a conviction for disorderly conduct arising from events that took place at the Green Bay VA outpatient clinic. The two issues before the court are whether the First Amendment bars the prosecution of disorderly conduct in this circumstance, and whether the statute governing control of the property at VA clinics, what's required to be shown, whether it's whether positive ownership has to be shown, and whether the language in the statute is an exception or a limitation. Both of these are issues which this court has not had to confront until today. And with the court's permission, I'd start with the second leg of the argument and move back to the first on the First Amendment ground, but I'm happy to answer questions regardless. In this court, and really throughout the country, there's not been any reported case law that talks about what proof of ownership is required to invoke the statutory language that the VA must control the property before proceeding under 38 CFR 1.218.
It's probably because this is a $250 ticket.
That's true. And just like anyone who has a conviction against them, there are certain attendant prohibitions and there are certain attendant things, and Captain Crayon Boole chose to take this to trial, and the outcome was that $250 ticket.
Sure, understood, but that explains why there hasn't been a lot of judicial attention to this statute. And to the point of what attention was paid to the statutory text and the regulatory text, because as I understand your argument, those two go hand in hand here, and the question arises as to how this was litigated before the magistrate judge in terms of the pretrial discussions among counsel and the magistrate judge about what the elements of the regulatory offense are. I know that this became a subject of the post-conviction litigation. I don't know that it was the subject of pretrial litigation.
Your Honor, when the pretrial litigation took place, this wasn't as hotly litigated as it became. It did arise at the trial at the motion for directed verdict, and I did reference that, and that occurs around page 182, 183 of the transcript. And essentially the magistrate took a guess and said that the language of the statute created an exception and not a limitation, with which, of course, we disagreed, and that's how this issue arose.
Mr. Lewis, does it matter, following up on Chief Judge Sykes' question, does it matter that in Section 901, or let's start with the regulation, does it matter that in 38 CFR section 1.218, right, the phrase "and not under the charge and control of the General Service Administration" is in parentheses, whereas in the statute, it's not.
Your Honor, I believe that the correct answer is the regulation was an essential restating of the statutory requirements. And in that case, the statutory requirement would govern over the regulatory requirement. The parentheses there simply have no bearing because the statutory requirement controls.
Can an argument be made that when promulgating this regulation, and that this regulation deals specifically with law enforcement and security, and so when they were promulgating this regulation, they intentionally put the parentheses down because they wanted to show what's to distinguish elements versus exceptions?
Your Honor, that argument could be made. If I recall correctly, there was some discussion of that in the review by the district court, and I believe the district court adopted something similar to that understanding. However, in the statutory language, the parentheses don't appear, and where the statute is inconsistent with the regulation, the statutory language must control.
Well, the statute in the parentheses doesn't appear in the statute because what 901 is doing is just defining department property. So the parentheses, the absence of parentheses seems completely understandable there. But in 1.218, they're actually setting forth kind of what constitutes various violations that are enforceable or sanctionable. And so it seems like the two provisions, one being the statute, the other being the regulation, really are directed towards two different things.
Your Honor, to my understanding, if the Secretary of the VA is establishing the offenses, as I understood you to indicate, he can only do that subject to the statutory requirement, which is that the property must be under the control of the VA and not subject to the administrator of GSA. It creates that limitation that the property must be under the control. Now, once you get to what the regulation establishes, which is the loud, boisterous conduct, et cetera, then the argument shifts a little bit as to what's meeting these criteria. But for overall, does it happen at VA? The statute is clear that the property must be under control of VA and not subject to the control of the administrator of GSA.
Does the GSA have a general disorderly conduct prohibition on property that it controls?
Yes, Your Honor. I believe it is in 41 CFR, and I believe it's somewhere in Part 100, but I would have to look at that. And I am not sure, to hopefully forestall the next question, I am not quite sure if the language there is exactly similar to what the VA's regulation is or not.
Did you want to address your First Amendment argument?
Thank you, Your Honor. On the First Amendment side, the Supreme Court spoke to this, as I noted in the Notice of Supplemental Authority, obliquely to this in Counterman, Colorado v. Counterman. And in that case, the idea came about that
That's a threats case before we go too far down this rabbit hole. It's not a fighting words case. And the whole argument that's being raised here is that this is not fighting words. So it's protected conduct. And I think both the district court who reviewed the magistrate judge's decision and the government basically say that it doesn't really matter if this was protected conduct because it's regulable under the forum doctrine, because this is a non-public forum.
And Your Honor, we did address that in our briefing, and the argument that we take there is that the VA itself opened the forum to expressive conduct and expressive speech. I listed some examples in my briefing. That's by no means as an exhaustive list, but when the facility itself chooses to open itself up, it chooses to reduce the protection that exists to regulatable speech.
So your argument is that this is a limited public forum? You're not arguing this is a traditional public forum?
No, Your Honor. At best, this would be I believe this would be a limited public forum, as the VA does maintain some control. But along that line, I would say that even inside what I would ask this court to do is go opposite the other courts that have looked at this, and to essentially say that veterans are not so broken that they need to have the full paternalistic protections that are afforded, and that is what the key to most of the holdings that have addressed this regulation. And with the court's permission, I will reserve the remainder of my time for rebuttal.
Thank you.
Thank you, Your Honor.
Ms. Tableson.
May it please the court, Rebecca Tableson on behalf of the United States. Captain Cramble honorably served this country as a captain in the United States Air Force. He is therefore entitled to medical care at the VA. He does not, however, have the right to yell and swear at VA medical providers, to slam tables, to swear at and insult VA police, or to threaten a fight on VA grounds. 38 CFR section 1.218 is a 50-year-old regulation that helps to ensure peace at VA medical centers. Those centers are not public fora of any type. Quite the opposite. They are designed to provide medical care to our nation's veterans in a private setting. And in a non-public forum like this one, the law tracks common sense, which is to say the government can limit access and speech with regulations that are reasonable given the purpose of the forum. As every court to consider this question has determined, the disorderly conduct restrictions in section 1.218 are reasonable restrictions of conduct in a VA medical center. This case shows why. Conduct like Mr. Cramble's can and did disrupt the VA's provision of medical care to veterans. The First Amendment does not require the VA's other patients, employees, other veterans to simply tolerate that. I'll briefly discuss the second issue presented as well. As both the magistrate and district judge concluded, the evidence was more than sufficient to show VA control of the Humphrey VA clinic in Green Bay. It is patrolled by VA officers, staffed by VA employees. The record is devoid of any suggestion that the GSA controls the clinic, and it does not. To briefly touch on Judge Lee's question about the parentheses in the regulation is the basis for this conviction, is the regulation that provides the elements of this offense. So the parentheses there are significant. And ultimately, the parentheses in the regulation make clear what common sense would dictate here, which is that the lack of GSA control is an exception. As this court has noted, and as has been a long common law rule, it simply makes no sense for the government to affirmatively disprove this exception in cases where, as here, there is not even a suggestion that GSA control exists. If the court has no questions, we respectfully ask that you affirm the judgment.
That interpretation of the statute creates no or the regulation, I should say, creates no due process problem of putting the burden on the defense for that exception?
I don't think so, Your Honor, for the same reason, the typical sort of common law rule is that a true affirmative defense that doesn't negate one of the elements of the offense, but that sort of brings a different defense to the table. The burden of production is traditionally on the defendant. So that's something like duress, right? That doesn't negate the elements of the offense. Instead, it's a separate justification about why what you did wasn't criminal. The same thing can be said here, although it's much more prosaic. about the lack of GSA control here. The lack of GSA control doesn't negate any of the elements of the offense here. It's simply a sort of, external issue that's otherwise orthogonal to the proceedings. If the defendant does think it's an issue, he can raise it and satisfy his burden of production. The government can still rebut it and carry its own burden of proof on that, but no, that does not create a due process problem.
It just basically, the phrasing of the statute clarifies that either one set of regulations control or the other for purposes of regulating this government property.
Yes, precisely, Your Honor. It's almost like a jurisdictional, threshold issue. And I also
but
want
jurisdiction
to know,
in the sense of which agency
Yes.
has control, not
Yes.
jurisdiction in
Not
the
federal,
sense that
yes.
the court has
no,
jurisdiction.
of course, we're all federal. Yes, absolutely. So I'm sorry.
So it doesn't operate like a jurisdictional element in
Yes.
another myriad sections of the criminal code.
Yes, absolutely. I just meant, which agency's police force is governing, what set of regulations are we under? And, I want to point out that Mr. Cromwell has never and still does not suggest that if this had been sort of affirmatively raised before trial and proven as an element, it would have made a difference in his case. It would not have. There's no indication that the Green Bay VA is controlled by the GSA. It is not controlled by the GSA. So I think, going to one of Chief Judge Sykes' questions to my friend, Mr. Lewis, we're talking, I think, about a little bit of gamesmanship here in terms of how this case was litigated, rather than about the true merits of whether what happened here was appropriate.
Are there government properties that are jointly controlled by the VA and GSA?
I wish I could give you a really straight answer on that, Judge Lee, but here's what I've learned in this case. The Veterans Administration building in Washington, D.C. is managed by the GSA. So I wish I could simply say, no, they're utterly mutually exclusive, but I cannot. What I can tell you is that a medical center like this one in Green Bay is entirely managed by the VA, and that's a different type of a building than the sort of Veterans Administration building in Washington, D.C. So I guess I could understand procedurally how it would be managed in a different way by the government. If the court has no further questions, we respectfully ask that you affirm the judgment below. Thank you, Your Honors.
Thank you. Mr. Lewis, you had used all your time, but you may have an additional minute if you have anything further to say.
Thank you, Your Honor. To go back, to go to the last statement my friend made, Ms. Tableson, if the headquarters building is GSA controlled, then obviously there are potential for other buildings to be GSA controlled. Indeed, that seems to be a feature of government nowadays, where ownership can be hotly contested or questioned. Along the lines of another statement that was made, there is a long and established history of veterans being upset with the VA and the care and lack thereof provided by that agency. To get right down to it, the screaming, cursing, etc., that is not only protected speech, but it also illustrates the lack of care to which the nation, through the VA, gives its veterans. And as such, in limited public fora, those statements and those expressions become protected. And for those reasons, Your Honors, we would, Captain Cranville asks that you reverse the conviction below and remand for any other proceedings that may become necessary on remand. Thank you, Your Honors.
Thank you very much. Our thanks to both counsel. The case is taken under advisement. And our final case this morning is Kimberly Barnes Staples versus Murphy. Speaking of the GSA. Come on up.
Say my client knows the answer, probably, not me. May it please the court.
You may proceed.
Ruth Major, on behalf of the appellant. The issue in this case is very simply the method by which the real estate director position was filled in this case. what we've looked at and we brought to the court is an argument very similar to the argument in front of this court in Christie versus Foremost, which is where we're not asking the court to make a determination on who's more qualified here. We're saying that the GSA violated their own policies, disregarded their own policies, in fact, and procedures, and did a number of other things that were inconsistent with how they normally do things in connection with promotional considerations. And that conduct was sufficient to create inferences that from which a jury could say, we believe this was a discriminatory process. In each and every case, the lower court came up with sort of an explanation. It inferred, drew inferences completely opposite of my client in favor of the moving party. And I just want to go through a few of these. It's important, one important point I want to make to start is that these guidelines do apply to the decision that's at issue in this case. There's been some argument by the GSA that it doesn't apply here. There's no documentation or support. If you look at the procedures, it says it applies to hiring decisions and these types of employment decisions. And what is in front of this court is the absolute decision as to who would get the job. And that would be the time it should apply. It's most important, not the time where it's least important to follow these procedures. These procedures were developed, and it says right there in the guidelines, that they were developed to eliminate or reduce the chances of discrimination in these types of employment decisions. And it's a voluminous document that lays out all of the things that the GSA should have been doing in this situation. I looked at the appellee's brief last night and noticed that at one point they say that Green, who was organizing this process, the second step, that he didn't know about the procedure, and that's absolutely false. They all knew about it. At docket number 76-4, page 35, in his deposition, Green is asked about it, and he says, yes, I knew about this, and I've been trained on it for 10 years, and HR even gave him a copy at the time of the second step. So all of these decision makers knew about this procedure, but they all intentionally disregarded very important parts. One of the most important parts was that they were supposed to come up with some questions for everybody, same questions. They did that. But even more important is they were supposed to come up with what the answer should be. What's a 5? What are we looking for a 5? What are we looking for a 4? And there's even examples in the guidelines. They completely failed to do that. They were supposed to each individually rate the candidates after they finished the interviews. They didn't do that. They were supposed to discuss and come to a consensus. They didn't do that. There's a dispute. 2 said that Ms. Acevedo agreed to the decision to promote Woodstock. Ms. Acevedo claimed she never gave any opinion on it. There was no. They were also supposed to consider under the procedure the whole picture of the candidate. Of course, that makes sense. What is their educational background? What is their work history? What are their performance reviews? What accomplishments do they have? The testimony in this case was that the decision was made after the interviews, based on the interviews, and that it took 10 minutes. There was no discussion. It was just, we think Woodstock's answers were the best to the interview questions based on our subjective assessment, and we're going to give the job to Woodstock. That is not consistent with how what the procedures dictate. They also asked a very job-specific question of the candidates that favored Ms. Woodstock. Ms. Woodstock was working in the real estate division, and there was a very nuanced question that she would know from working there. And again, the procedures say and things that people can learn on the job should not be asked about. It should be questions that any candidate, inside or outside, knowledgeable about the exact work that's going on or not knowledgeable, could answer equally.
But didn't that question go to an issue that the real estate director position, that the person whoever it was who would be hired in that position would be expected to address? And it just happens that Ms. Woodstock has prior experience in the real estate department, but the position for which GSA was interviewing for was someone in the real estate department that has to address those types of issues.
Right, but it wasn't, according to the procedures, the questions are supposed to be geared to determine whether the person has the competency, the knowledge, the skill set to handle those issues, not whether they have specific knowledge that only somebody currently working in the department would know at the time. And that's where the issue comes in. There's not supposed, because then it's not a level playing field. Because if you're asking something, and they all admitted that Cheryl Woodstock would know that because she was working in the department.
Well, it's kind of like, say, hypothetically speaking, a school is interviewing for a math teacher position, and they have two interviewees. One, was a former math teacher, and the other one was a former history teacher. And so they asked both candidates, well, do you know algebra? Because algebra is something that the position, whoever gets this position, will have to teach. And do you think that question is unfair?
No. I think if they said, what do you think we should do about some of the specific students that have been struggling with algebra? That's where the problem would come in, because it's not something that people inside or outside could answer based on their general knowledge. It's a department-specific question that gives the upper hand to somebody who's actually worked in the department recently. And that's the problem here. And the procedures caution against asking about things that you can learn on the job. So a general algebra question absolutely would be appropriate, but a question specific to that school, to that department, that only people working there would be able to answer, gives the upper hand to the candidate who actually, and in this case it was a softball for Cheryl Woodstock. And that's what it was. It was a softball question for Cheryl Woodstock, and something people outside wouldn't be able to answer because they don't have that departmental knowledge, which is just specific to what's going on at the time.
Ms. Major, do you
Yeah?
think they were giving softball questions to candidate Roberto?
I don't know offhand what candidate Roberto's knowledge was of this specific issue because this was something that Cheryl Woodstock had been involved in. But I can't speak to Roberto. I can speak to my client and Ms. Woodstock. And it was something my client would not be able to.
Well, I'm just trying to look at the relevant scores.
Mm-hmm.
And your client comes in third, as I understand.
Through this process, yes.
Yeah.
Through this process, which we believe is from start to finish, well, at least with the second step, was tainted. Okay? So, yeah, I mean, it's very hard to talk. This whole process from the beginning to the end, as it concerns this final step, almost every, I'll say half of the aspects that they were, steps that they were supposed to go through and cover, they didn't.
If they've asked the softball question of Ms. Woodstock, that's inappropriate under your suggested what has occurred here.
Mm-hmm.
So do you throw out everything is that a situation of almost harmless error? I mean, does one softball question give the big difference in the number scoring here?
Well, it's one aspect of this, the totality, which we talk about in Ortiz, the court talks about in Ortiz. It's one aspect. I'm not saying that alone would be it. More importantly here, in my opinion, and it is the fact that they didn't have the answers, the rating scale established, which created complete subjectivity. They didn't consider, that my client had an MBA. We never said, and I saw this in the brief, we never said she should get the job because she has an MBA. But that should be a consideration. A graduate degree, everybody on the panel had an MBA. They hire from MBA panels. So this is one more. There's just a number of these, and we've listed them in where they just disregarded their normal procedures and essentially set it up so that one person would stand out among the rest, and that was Cheryl Woodstock. So I don't know if I have any time to answer your questions, but
Actually, you don't. I'll give you a little time in
okay.
rebuttal.
Thank you so much.
Mr. Lindland.
Please the court, counsel. What she's really complaining about here is she wanted the director's job. That's the top job, the head of a division where she hasn't worked in for about 10 years. Now, the person who got the job, Ms. Woodstock, had been there for 18 years, the last 10 of which she was in a manager's position. In fact, right before this promotion, Ms. Woodstock was the acting deputy director. So it's not that surprising that someone like Ms. Woodstock would get this position over someone like the plaintiff who hasn't worked in the division for 10 years. I mean, it's like, let's say a restaurant's hiring for their head chef in the kitchen, and they have a choice between a person who's worked in the kitchen for 18 years and is managing all the sous chefs, they're like the top, sous chef manager, versus someone like the plaintiff who is working in the accounting department for the restaurant or managing some of the wait staff. It wouldn't be surprising to hire the top sous chef that's been there for 18 years. So what they're trying to do now is pick apart the process, find any little tiny technicality or detail that the GSA didn't follow, and then point to that and say that's discrimination. But as the district court correctly found, that's not how it works. You can't just take a few little detailed deviations and say, oh, that's a systemic and blatant deviation from a hiring policy.
Can we talk about the applicability of the guidelines to the second round interviews? As I understand GSA's position, the guidelines do not apply to that second round. And I was wondering if you'd be so kind as to point me to a document that simply states that. Because the Gelber directive does not.
That would be docket 80-6, Exhibit 34, which is the unrebutted declaration of Ms. Bocanero. She's the HR specialist assigned to this specific promotion. And as she testified, the guidelines did not apply to the second round because they used them in the first round. And then she talks in detail about why that's true. They argue that there's no foundation for this testimony, but in fact, that's her job. Her job is to make sure that the correct process is followed by the selecting official as well as the interviewers. But the guidelines, well, first of all, the bigger problem for the plaintiff here is the GSA did everything right. They followed the guidelines to a T. In fact, as the district court put it, they scrupulously followed the guidelines in the first round interview. And the second round interview, they complied with what is known as the Gelber directive. And the main part about that directive is that the commissioner at the time, Bruce Gelber, wanted to have someone from his immediate staff involved in the interviews and the selection. And in this case, that was Ms. Acevedo. And they followed that directive. They conducted the interviews. They talked about the candidates. The selecting official, Mr. Green, said, I would like Ms. Woodstock for this position because her answers demonstrated a better knowledge of our challenges and had a plan to meet those challenges. And so he then passed that recommendation up to the regional commissioner, who passed it up to the commissioner, who then, with Ms. Acevedo's concurrence, he approved that recommendation. And so the other thing to keep in mind is there was not one interviewer that thought the plaintiff should get this job. Not one. All three interviewers thought that Ms. Woodstock was the most qualified. And the interview questions that they asked and the way they did the questions, they asked the exact same question by the exact same interviewer in the exact same order to each applicant. And they gave each applicant the same amount of time to answer those questions. No reasonable jury would find that process to be discriminatory. And you mentioned the guidelines. Even if they did apply, any deviation from them was applied equally across the board as to all the candidates, such that there could be no inference of discrimination raised. And that's what this court found in both Coleman versus Donahue and Jall versus Valparaiso Community Schools, both of which the district court correctly relied upon in this case, and we cite those in our brief.
Is it correct that when Mr. Green prepared the questions for the second round, he didn't know who the candidates were going to be sitting
correct.
for the interview?
That's correct.
And so he had no opportunity to kind of tailor the questions to Ms. Woodstock versus Ms. Barnstable.
He didn't know who was going to be in the second round when he developed those questions. But if you look at the questions that they asked, they're exactly the question you would expect them to ask of someone who's the director. Things like, what are the challenges of the division and how would you meet them? That's a question that you would want to know if you're hiring somebody to run an agency. Now, it would be different here if, for example, they applied the guidelines in the second round to only the plaintiff but not the other candidates, or if they applied the guidelines to only the other candidates but not the plaintiff. But that's not what happened here. It was an across-the-board deviation, if there was a deviation, and there wasn't. Her complaints about the process are unsupported. She claims her qualifications weren't considered. Of course they were considered. They were considered in the answers she gave in the second round interviews. She complains about, she had an MBA and the selectee didn't. That was not a requirement for the job. You didn't have to have an MBA for this job. She claims that the questions were tailored. No, they weren't. Again, if you take a look at the questions, the second question was a hypothetical. The commissioner has increased the leasing performance standards for the region by 50%. How would you address that challenge? Maybe that wasn't a hypothetical. Maybe that was an actual problem that the division was trying to figure out. The GSA has a right to pick the person that can solve their problems. And that's what this interview was all about. She claims that the interviewers lied in their depositions. They didn't lie. As the district court put it, the plaintiff boldly but inaccurately claims they lied. They described the process in slightly different terms, but that's not lying. They all painted a consistent picture of what happened. The selecting official, Mr. Green, decided he wanted Ms. Woodstock and passed it on up to the commissioner. The bottom line here, though, is that the plaintiff simply presented insufficient evidence, actually no evidence, to demonstrate that the reasons for her non-selection were pretext for discrimination. As for her other claims, her intersectional discrimination claim and her retaliation claim, she failed to exhaust her administrative remedies for those. In fact, she didn't even address the exhaustion argument in the district court, nor did she address it here, and so therefore those arguments are waived. Her statistical evidence argument, too, was not raised in the district court either. She refers to a motion to compel, but of course the motion to compel was not part of the motion for summary judgment record. Unless the court has any further questions, we ask that you affirm the decision of the district court.
Thank you. Ms. Major, your time had expired, but you may have an additional minute if you have anything to say in rebuttal.
Sure, I'll talk very fast. All of the panel members who testified admitted that the procedure did apply at the second step. That's in the record. The panel admitted that the question was that we say favored Ms. Woodstock was something that she'd be able to answer and people outside would have difficulty with. The issue here isn't whether counsel believes Ms. Woodstock was more qualified or whether the lower court. The question is whether there's sufficient evidence here that calls into question whether this was a discriminatory process that prevented my client from being selected And without having this process correct, we're never going to know how this would have turned out had they followed and done the right thing. Finally, we did address the intersectional discrimination repeatedly. It's the gender and the race, and that's always been a part of her case, and it was addressed in our briefs. And I thank you very much for your time and your consideration.
Thank you very much.
And
Our
have a great
thanks.
day.
Thanks to all counsel. The case is taken under advisement and the court will be in recess.